What are Australia's current policies in relation to protection for refugees who arrive by boat? Historically, Australia granted permanent protection to refugees. However, under the Howard government, a new kind of visa was created known as the temporary protection visa. The way this operated was to say that if somebody comes to Australia by boat, then they will no longer be eligible for permanent protection. Rather, they will only be eligible for a 3-year temporary protection visa. Under the Rudd government, temporary protection visas, or TPVs as they came to be known, were abolished. However, the new Abbott government has reinstated them. And one of the principal rationales behind them is the idea that this will deter people from coming to Australia by boat because they will never be able to permanently resettle in this country. So what are the features of temporary protection visas that make them so different from permanent protection visas? Well, apart from the fact that the duration is limited and probably at most will last for 3 years, temporary protection visa holders have to have their status reassessed every few years. And of course, that means that people are often living in some kind of psychological limbo, never knowing whether they might be at risk of being returned to the place where they fear harm or whether they'll be able to remain in Australia. And obviously, this makes dealing with the trauma that one has experienced, as well as building a new life in Australia, very, very difficult. In fact, psychological studies show that on every measure, temporary protection visa holders have far greater psychiatric and mental health disturbances when compared with permanent protection visa holders. In 2006, a Senate inquiry found that TPVs did not have the deterrent value that the government had hoped they would have. And in fact, they said there had been considerable human suffering as a result. In particular, there was evidence that more women and children ended up making dangerous boat voyages to Australia precisely because TPV holders are not allowed to bring their family members out to Australia to reunite as a family unit. And the result was that more women and children died at sea. What's the history of offshore processing in Australia? In 2001, the Howard Coalition government decided to create what was known as the Pacific Solution. In essence, Australia excised around 5,000 islands from Australia's migration zone and said that asylum seekers who came by boat would be transferred to other countries, namely Nauru and Papua New Guinea, for processing offshore. As a matter of international law, Australia couldn't get rid of its international obligations to refugees and asylum seekers. But what this system sought to do was to move asylum seekers physically outside Australia and to make their access to the procedural protections and to Australian courts and reviewers impossible. In 2008, the Rudd Labor government dismantled the Pacific Solution, saying that it was a cruel policy, that it didn't work, and that it was not something that a Labor government would ever pursue. However, in 2012, the Labor government revived the policy. At that time, Labor created what's become known as the Pacific Solution Mark II. It reopened offshore processing centres on Nauru and on Manus Island in Papua New Guinea. And in July 2013, Prime Minister Rudd went even further. This time, he said that refugees who reached Australia by boat would not only be processed in other countries, but would never be able to come to Australia and be settled here. Instead, they would remain in Papua New Guinea. While the Refugee Convention doesn't prohibit offshore processing outright, this is because the drafters of that treaty never envisaged that countries might seek to distance their obligations in this way. In mid-2013, Australia's Joint Committee on Human Rights, which is part of our Parliament, found that Australia's package of regional processing legislation violated many of Australia's obligations under international refugee and human rights law. First of all, offshore processing unlawfully discriminates between asylum seekers based on their date and mode of arrival. Those who arrive by plane in Australia are processed here. Those who arrive by boat are sent to offshore processing facilities. Secondly, conditions in offshore processing facilities fall short of minimum international human rights standards. Access to healthcare, freedom of movement, access to education, to work, and so on are all severely restricted, if not denied altogether. Thirdly, the cumulative impact of the policy, both on people's physical and mental health, may amount to degrading treatment under international human rights law. Australia has itself undertaken not to send people back to places where they face inhuman or degrading treatment, and yet here there is a risk that Australia is sending asylum seekers precisely to that form of inhumane treatment. We know that there are high levels of self-harm, that people are suffering significant trauma and mental distress, and this is likely to be prolonged when people are held in offshore processing facilities indefinitely. Fourthly, the prolonged and mandatory detention of asylum seekers on Nauru and Manus Island clearly violates the prohibition on arbitrary detention in Article 9 of the ICCPR. Detention is only lawful if it is necessary, reasonable, and proportionate in all the circumstances, and can be periodically reviewed by a court on an individual basis.